Okay.
Nikki. Okay,
Oh,
go ahead.
okay, great. Hello and welcome everyone to our first Big Bang workshop of the season. We're excited to have Vicky Lee here from DLA Piper. And Vicky's been doing this presentation with us for quite some time. She's a great resource and really knows this topic well. I'm going to go ahead and put Vicky's LinkedIn in the chat so that way you can take a look at her background and who she is before we get started. But welcome, Vicky, to the Intellectual Property Workshop, and go ahead and get started whenever you'd like.
Okay, great. Thanks, Nikki. Well, first of all, Happy New Year, everyone. Hope everyone had great holidays. And for those of you who maybe either are based in Southern California in the LA area or have friends or relatives down there, it's really tragic what they're dealing with. And so, certainly our thoughts are with you and your friends and family as they work through this challenging time. Certainly not a great way to start the year, but, keeping you all in our thoughts. As Nikki said, I'm a partner at DLA Piper. We are a global law firm. I'm just going to advance the slides here. We have lawyers located in 90 plus offices in 40 plus countries across the Americas, Europe, the Middle East, Africa, and Asia Pacific. I myself am based in Northern California. I was born and raised here in the San Francisco Bay Area. And fun fact about me, I'm a double Davis grad. And so when Nikki and Joe asked me to either do one of these Zoom presentations or go back to Davis physically to do a presentation, I'm more than happy to do so. I'm going to date myself a little bit now, and I graduated as a history and econ major in 1990 from the College of Letters and Science, and then stayed for another 3 years and graduated from the King Hall School of Law. And so I'm a very, very proud Aggie. I am one of about 500 IT and technology lawyers in the firm globally. We have a global open source practice and a chambers ranked IT and technology practice. And so we're really proud of that. I've been practicing for about 30 years in the technology and IP transactions space. I work with companies that are, the largest global technology companies in the world, all the way down to first-time entrepreneurs and emerging growth companies. And so I like doing this presentation because from where I sit in both geography, from a geographic perspective, as well as from a practice perspective, IP is a core asset for most of the companies I work with. Whether you're a global company, global technology company, or whether you're a first-time entrepreneur, you need to understand the role of intellectual property in the formation of the company and in executing the business strategy. So what we're going to talk about today is, why is IP important? What are some of the IP issues and formations of a company? And then what are investors looking for? So all kind of aligned with why you are all part of the Big Bang program. So why should you care about IP? We kept you all waiting in the waiting room for a little bit because I was struggling with my laptop. I was having some IT issues and saving documents, but on this particular slide, I had actually updated this slide hot off the presses from the Motley Fool as of this morning. This shows the largest global companies by market cap in 2023, but as of January 2025, the largest global companies by market cap are Apple, and then number 2 is NVIDIA, and then we go to Microsoft, Alphabet, and Amazon. And currently, 8 of the top 10 largest global companies by market cap are in the technology sector. And again, that is from the Motley Fool. So why is that important? If you look at this slide that shows the largest market cap companies over the course of the last 50 years. Back in 1975, the largest companies were IBM, ExxonMobil, Procter and Gamble, GE, and 3M. So what do those companies generally have in common? Those companies, you can see on the bar graph, it might be a little bit small, I apologize for that, but the red shows the value of those companies as a function of their tangible assets. What you're seeing in the black or the gray over time is the value of the companies as a function of their intangible asset. And so you can see in 1975, the value of the top 5 companies in the S&P 500 was almost entirely based on their tangible assets. So their fixed assets in terms of equipment, real estate, and the like. Very little in the way of intangible assets. As time goes on, you can see from 1980, starting in 1985, and then all the way up to 2018, you can start to see the value of the intangible assets starting to make a difference in the market cap of these companies. So not much change in 1985, but and then a little bit of change in 1995. The companies are still mostly more traditional, maybe non-tech companies, but you can see that the relationship between tangible assets and intangible assets is starting to shift. And then starting in 2005, you can see now Microsoft is now number 3 in terms of the highest value companies. And you can see that the value of the intangible assets is really starting to eclipse the value of the tangible assets. And then in 2018, the companies like that had their value mostly in fixed or tangible assets are no longer the most valuable companies. And now it's dominated by technology companies like Apple, Alphabet, Microsoft, Amazon, and Facebook. And then again, now fast forward to January of 2025, you have NVIDIA there now, and then Saudi Aramco has dropped out in the last few years. So what does that mean? It means that intellectual property, the value that we place on intangible assets, and the importance of those intangible assets in terms of how a company grows or executes on its business strategy is increasingly important for the largest companies these days. And then certainly for companies that are just going to start off the ground. Here in this next slide is a different representation of the same idea. You're seeing that intangible assets are now 90% of the value of S&P 500 companies. And the value of the intangible assets in the S&P 500 companies from 1975 to 2020 have tripled. And then the biggest change has happened between 1985 and 1995. The global economy is moving away from its industrial foundation and moving more to an economy that's based on knowledge, capital, and services. And that's where the value is going to be the likely driver going forward. And we're seeing that with this emphasis on artificial intelligence, AI, and data. I'll talk about in a little bit the different categories of intellectual property. And data, though it's not technically one of the traditional forms of intellectual property, data as an asset is increasingly important. And companies that are built around data-centric business models are likely going to be kind of the future of the economy, especially with the focus on AI. And you're seeing that with companies like NVIDIA, their value increasing in kind of exponential proportions. So what do we mean? And then Nikki, it's a little bit harder to do since we're not in person, but if anyone has questions, I would really love it to have this be more interactive as opposed to me being screen, a square on those respective screens in a gallery. So Nikki, if there are questions in the chat, if you wouldn't mind interrupting me, I'd appreciate it.
Will do.
Okay. I did see two things in the chat, but maybe those aren't questions. Oh, yeah, you feel free to put in the chat. Okay, perfect.
Yeah.
Okay. So what do we mean by intellectual property protection? As I said, there's kind of the classic forms of intellectual property in terms of patents, trademarks, copyrights, and trade secrets. But one thing that companies and founders often forget is that intellectual property protection is jurisdiction by jurisdiction, or country by country in non-legal terms. So what do we mean by that? What we mean is that if you have a patent in the US, that does not mean that your invention is protected in the UK. It doesn't mean that your invention is protected anywhere outside of the country in which the patent has been issued. There are ways to have multi-jurisdictional protection with the filing of an application. That's achieved by various treaties that countries sign up to. So the Paris Convention is one. In the last few years, there's also been a movement in the EU to develop this unified patent court, where patent infringement actions can be brought across multiple EU jurisdictions in a single court. You can also file a unified patent in the EU member countries as well as a European patent. So there are ways to have multi-jurisdictional and multi-country protection, but you need to take active steps to protect the invention in those multiple jurisdictions at the same time. It doesn't happen automatically. Failing that, the patent protection is country by country only. Same thing with trademark. If you have a trademark registered in the US, that trademark registration is only good in the United States. It's not good outside the United States. Some of you might see on occasion the R with a circle around it. That indicates a federal trademark registration. If you see something with a TM next to it, that means that whoever's using that mark is treating that as a common law trademark, but it's actually not registered in any particular country. Copyrights, most first world countries are parties to the Berne Convention. What that means is that copyrights in works of authorship are treated similarly. But again, it is country by country. The interesting thing about copyrights is you can have a valid copyright without actually having a registration. You do not need, for example, for many of the companies I work with in the tech space, it's rare that they actually file a registration for their software. Software is a work of authorship. It is protectable by copyright, but you don't have to register the copyright in order to have a valid copyright in the software. The reason most software companies don't file the registration for the copyright is it's not that it is difficult to do or it's very time consuming or expensive, but software evolves at such a rapid pace that oftentimes a software version is outdated before a company actually seeks to enforce any rights in the software. And it's generally a bad business practice to be suing your customers who are using your software. And so, and that's really the benefit of having a copyright registration in place. If you are planning to enforce your copyright rights against a third party, you do need to have a valid copyright registration on file with the U.S. Copyright Office. But again, because most software companies are not in the business of suing their customers, and because software versions get outdated so quickly, it's generally not useful for software companies to file registration for copyrights. On the issue of trade secrets, so trade secrets have historically been protected in the US on a state by state basis. Not all countries recognize trade secret protection, but here in the US we do. And so nearly all states now have adopted the Uniform Trade Secrets Act. But back in 2016, the federal government also passed a federal trade secret law, the Defense Trade Secrets Act, and that provides federal protection for trade secret for trade secrets. And so that's still relatively new. And it requires certain notices to be included in employee agreements that we'll talk about in a little bit. But if you just keep in mind that, generally intellectual property protection is enforced country by country. So let's dig a little bit deeper into the different types of intellectual property, at least recognized here in the US. Okay. Patents. So the patents are actually a right granted to Congress in the US Constitution to encourage inventors by giving them it encourages inventors to innovate by giving the inventors exclusive rights to their invention. Here on the slide, I have human inventors highlighted in red because with the focus on artificial intelligence right now, and in the foreseeable future, there's been a question as to whether or not an invention that's actually created through the use of artificial intelligence is entitled to patent protection. There are some countries that have passed laws that allow inventions created through artificial intelligence to get the benefit of patent protection. We have not done that yet here in the US. The US patent law hasn't actually caught up to the use of AI quite yet. The patent law was written on the assumption that the inventors are human inventors. You might have seen in the last year, the USPTO has issued some guidance on when something is patentable, when inventorship has been assisted by AI. And so while we haven't categorically denied protection to inventions that are kind of developed or facilitated by AI, it really depends on the amount of human contribution that's been made.
We have a question.
Yep. That's been made to the invention. And so it is still very much a case by case basis. But the guidance is that there needs to be significant human contributions involved.
Hey, Vicky?
Yep.
We have a question regarding one of the bullet points on the patents. What is a plant?
Okay. So what can be protectable? So invention, designs, and plants. Plants, literally, I mean like plants. So coming from, Davis, there's a lot of work that, in developing, new, combinations of plants. Maybe they are more resilient to certain types of weather, more resilient to maybe certain types of bugs. So those can be protectable by patents. It's a very specialized area of practice. My firm doesn't actually do a lot of work in plant patents, but you can get protection for plants and seeds. And my guess is that there's probably lots of, a good number of professors at Davis that are working on those types of inventions. what other types of inventions can be protected? So design patent. So design, the example I like to use for design patents is, that kind of bulbous egg-shaped Mac computer. That design was protectable by a design patent. The most common type of invention that's protectable is, with a utility patent, where, you think about your big screen TV, there's likely lots of patents that are, identified by patent number, either in your user documentation, it might be stamped on the back of the TV, but, there's patents probably in the chips, the way the display, is set up. So those types of utility patents, I think, are the more typical types of inventions that people think of when they think about patent protection. Here in the US, the duration of patent protection is for 20 years from the filing date of the application. And the exclusive rights that are given to the inventors are the right to make, use, sell, import, and have pay. So hopefully that answers the questions on plants and designs. If not, feel free to jump in and ask me another question. Moving on to copyrights. Similar issue here, the rights are granted to Congress in the US Constitution to encourage authors, again, human authorship, by giving authors exclusive rights to their works of authorship. So copyrights don't protect ideas, they protect it protects the embodiment of an idea once it's reduced to a tangible medium of expression. So the typical copyrights are songs, compositions, plays, books, and then in my professional world, software. So software code is, the functionality is reduced to a tangible medium of expression with the zeros and ones of the software code. In some respects, the Copyright Act, similar to the Patent Act, has not caught up with technology. There are aspects of the Copyright Act that speak more to traditional forms of works of authorship as opposed to even software. And certainly when it comes to, artificial intelligence, it hasn't caught up. So just like with patents, there is a level of human involvement and human contribution that needs to be incorporated into a work of authorship for a work that's generated by AI to receive copyright protection. Prompts alone are not protectable by copyright. And again, some additional guidance from the Copyright Office that came last year for those of you who want to register your copyright or your work of authorship, to the extent that there is a portion of it that's generated through the use of artificial intelligence, you now need to specify in your registration application which portion was created with a human contribution and then which portion is the non-human content. And the AI generated content that's any more than kind of de minimis would be excluded from the scope of that copyright registration. That might change in the future as the use of AI continues to expand and evolve. But for right now, that's the requirement for copyrights to the extent AI is involved in the production. So what are the exclusive rights granted to a copyright holder? They're the rights to reproduce, the right to distribute, prepare derivative works, or the right to modify, and then the right to publicly perform and publicly display. Those rights, you can see they're more catered towards, say, plays, songs, books and the like. But you can see where publicly display could also apply to, you know, web pages, maybe some databases, or at least the content of the databases. Next category of intellectual property is trademarks. So when I talk about trademarks, I'm also talking about logos, brand names, service marks. So what are trademarks? They identify the source and the quality of goods and services. Here in the US, the duration of a trademark registration is 10 years from registration. It's renewable so long as you're continuing to use the mark. We talked about the common law rights indicated with the TM. And so what can be protectable? The strongest trademarks are those that are arbitrary, have no relationship to what the good or service actually is. So descriptive marks are generally weak and may not even be eligible for trademark registration. So what do I mean by an arbitrary mark? You know, you think about the Apple logo, that Apple half-bitten symbol, you know, you wouldn't ordinarily think about that as being for a computer, right? When Apple Computer first started. That logo would qualify as an arbitrary mark. It's a very strong trademark. You know, calling something an elevator or an escalator, those actually started off as trademarks, but over time they actually describe you know, in the case of an escalator, they actually describe a moving staircase. And so that's a situation where an arbitrary mark kind of lost its value over time, because it became more descriptive. Same thing with Kleenex, Band-Aid. So those companies who own those marks have had to do a lot of work to try to keep those marks arbitrary and move away from being descriptive. And so when you're starting your company, when you're coming up with product names or even a name of the company, coming up with something that's not tied to what the product actually does or what the business actually is about is going to give you a much stronger trademark protection than having something that's very descriptive. So, you know, like if you say, cybersecurity company, cybersecurity are us, like that's not a very strong mark, right? So it describes a company that's likely providing cybersecurity services, right? Whereas if you said, Canary, you know, company, that has no bearing to cybersecurity services. It's Canary, it talks about a bird, right? So it can be anything. And that's an arbitrary mark. AI is also important in this context. So you might hear about companies that are using generative AI to come up with creative arbitrary marks. I am not a creative person. If you ask me to come up with a really catchy trademark or logo or tagline, I probably wouldn't be able to do it. But if I had some help with an artificial intelligence, you know, tool, maybe I could come up with something that was really creative and really interesting. The problem is that when you are using those platforms to come up with trademark ideas, especially those that have that are leveraging publicly available databases and information, you have no idea where they're getting that information from. You don't know the origin or the source of this really what seems to be a very creative trademark or logo or tagline. For all you know, the AI engine might have taken part of that mark from someone else. And so if you use the trademark without having some level of oversight, a human oversight, to run searches to make sure that this trademark that was created with the use of generative AI doesn't infringe on someone's else's mark out there, then you run the risk of investing a lot of dollars into a trademark only to have someone raise an issue with you later on. And so while it I think can be very useful to leverage the power of AI to help with generating trademarks and service marks, logos, taglines, brand names, and the like. Our recommendation to our clients and my recommendation to all of you is that when you settle on something that you maybe want to use as a mark, still go through the process of having that mark checked, kind of the old-fashioned way to make sure you're not inadvertently infringing on a third party's trademark rights. On the issue of trade secrets, so trade secrets can be anything. It's any non-public information that provides a competitive advantage by virtue of not being made publicly available. And actual efforts are taken to maintain that information as a trade secret. Where does AI fit into that type of intellectual property? So I have lots of clients who are asking me about using AI to help with product development. Well, depending on what kind of information you're feeding into the prompts to these AI engines to come up with product development ideas or maybe bug fixes, you want to make sure that you're not feeding trade secret information into these prompts. There are enterprise versions of some of these AI platforms like ChatGPT. So there's ChatGPT that's available to anyone. The free version, maybe there's the premium version that you pay for, but there's also an enterprise version. What does the enterprise version get you? It gets you more security. It gets you at least a commitment that the information you're feeding into the prompts are not going to be used to store or not saved and stored and used to train the algorithm in the future. That's not the case with the public version. Whatever you feed into the prompts, you have to assume that it's going to be sitting in a database somewhere and you have really no idea who's going to have access to it. And why is that important from the perspective of trade secrets? It's important because of the definition of trade secret. If you're not taking efforts to maintain the information as a trade secret, then you don't have trade secret protection. And so if you are arbitrarily feeding information into an AI tool, and that AI tool has no kind of security around the protection of that information, then you've given someone an argument that you haven't taken efforts to maintain that information as a trade secret, and you've lost trade secret protection. Why is that important? Trade secret protection is theoretically forever. So long as you take steps to protect the information as a trade secret, you could protect that. You could maintain trade secret protection forever. The example I like to give here is the Coca-Cola recipe. Anecdotally, there's a very small number of people within Coca-Cola that know the recipe for classic Coke. It's under lock and key. The people who know the recipe are supposedly not allowed to fly on the same plane together. They have shown that they've taken steps to protect that information as a trade secret. And so that's why the Coca-Cola recipe has been maintained as a trade secret as long as it has. The rights that are granted to trade secret owners are the right to use and disclose. You control, as a trade secret owner, you control who has a right to use your information, who has a right to disclose that information, and how can it be used. What can be protectable? Secret invention. So using software as an example. When we use software, we use the object code of that software. It's the the code that's compiled by the computer, right? It's not the human readable source code version. The human readable source code version can be protected and should be protected as trade secret. Okay. So software companies rarely give a license to their source code. They rarely give a license to their source code because they don't want the source code to kind of be accessible, in an unfettered way. Customer lists, pricing information, that can be trade secret information. The other thing that I like to remind people of is information that's not useful can also be treated as trade secret information. So I call it negative information. Knowing what doesn't work can be as valuable as knowing what does work. So if you think about two companies that are trying to develop a new drug, one company finds out that a certain formula doesn't work. So they're able to pivot and, try working on a different formula. The other company, who's a competitor, they have no idea that the path they're going down is going to lead them to a formula that doesn't work. Had they known that, they might have also been able to pivot like the first company. And so the fact that the first company knows that a particular formula is not useful or doesn't work, that could be valuable trade secret information as well. So please keep that in mind when you're thinking about what information could constitute trade secret information. So now you want
Got
to
another
start.
question for you.
Yep.
So could you please provide an example of a court case on trade secrets that are won by the owner of the trade secret?
I mean, there were some recent examples. I don't remember exactly the company. I think it might have been Western Digital, actually. So, this kind of industrial espionage happens pretty often in Silicon Valley, actually. And so I think it was last year or the year before. There were some employees of a company who were accused of taking the trade secrets of their former employer and taking them to a competitor company. That former employer sued those employees and they won. So that happens quite a bit. And that's a great segue to the next set of slides. So some of the issues to think about when you're starting a new company. So if you think about the employees in that case that I just mentioned, you don't want to be in the position of one of those employees. And you don't want to be in a position of hiring one of those employees, because what happens in those industrial espionage cases is the former employer not only sues the individual employee that is accused of stealing the trade secrets of their former employer, but they also often end up suing the new employer, right? And so whether you're starting your new venture as a startup company, a brand new entrepreneur, or whether you are a global company and hiring new employees for one of your engineering sites, you want to make sure that those employees are not coming with any trade secrets of their former employer. So, the issues that often come up for employees as they leave a company is, what can they take with them? If they're an entrepreneur and they're starting their own company, when is a good time to leave their former employer and start their new company? Because there's this tension with getting a steady paycheck, right? And oftentimes when you're starting a company for the first time, you do not have there's going to be likely some period of time when you don't have a steady paycheck, right? And so finding when you can leave your former employer and leave with what I call clean hands So you don't create a problem for yourself when you start the new company. Those are important considerations. And then, can you work on your new venture while you're still working for your current employer? That is, again, the consideration of how long can I live without a steady paycheck, right? And so how do we answer some of these questions? So let's start with ICHPs for the founder. What is your current employer own? For those of you who work with or are currently employed, you probably signed some form of employee proprietary information, confidentiality, inventions assignment agreement. We call them PIAs. So what does that agreement say? I don't know if any of you read it in detail, but they likely had a confidentiality clause. So it required you as an employee to maintain the company's proprietary information and non-public information as confidential. As we said, the agreement probably restricted how you could use or disclose that information. It probably included an assignment of intellectual property rights. So it confirms that anything that you develop while you are employed by the company is owned by the company. And then here in the US, we actually recognize a concept called work for hire. So as an employee, even if you sign no agreement, all works of authorship that are protectable by copyright are automatically owned by the employer, so long as the employee develops it within the scope of their employment. So if you're hired as a software engineer, you don't sign any agreement, but you write software code, your employer, the company, is going to own that software code. That's not the case for patents. So inventions that are protectable by patents do need to actually be assigned to the company that you're working for, which is why it's we consider it a best practice to have these types of agreements signed as part of the onboarding process when an employee is newly hired. But what the employer gets instead, if there's no agreement, is that they get a license. We call it a shop right. So they get a license to use the invention, but they are not themselves the owner of the invention unless there's a written assignment agreement. The work for hire doctrine does not apply if you're a consultant or a contractor. So many entrepreneurs or many founders will start a company and they will not pay themselves as an employee, because as an employee you have to pay minimum wage, and when you're just starting off, sometimes you can't afford to pay even yourself minimum wage, and so they pay themselves as a consultant or contractor. There are potential employment issues associated with that, which I won't get into, but strictly from the perspective of intellectual property rights, a written agreement between a company and a consultant or contractor that they hire is required in order for an enforceable IP assignment. So I run into a situation very often where companies believe that they have paid a contractor, or they paid a consultant, and they own what that consultant or contractor has developed. They have no written agreement in place. They're horrified when I have to give them the bad news that because they didn't get a written agreement in place, they have the consultant or the contractor actually owns what was developed for the company. It's unfortunate because, like I said, in most situations, the company is already paid for the work, but a written agreement is required for an enforceable assignment of the intellectual property rights. There are certain types of work that's commissioned that can be commissioned by from an independent contractor, where work for hire does apply, but it doesn't typically apply in the context of a technology company. So things like an architect, like architect's plans, those are the types of work that can be commissioned from an independent contractor that can be owned by the party hiring the independent contractor without a written agreement. But in the situation where you're a technology company or life sciences company, or you're having something developed for you, outside of these, kind of special 9 categories of works, you need to make sure you have your written agreement in place with your consultant or contractor. Otherwise, you're giving them an opportunity to hold you hostage. And usually those issues pop up at very inconvenient times, like when a company is about to get some financing, or when a company is about to get acquired, and you don't want to put the company, or you don't want to, as a founder, put yourself in that situation. What are some other restrictions on founders that they need to keep in mind when they're starting a new company? Non-competes. So the good news here from an employee perspective is, in California, non-competition or restrictive covenant clauses are not enforceable except in very limited circumstances. And those limited circumstances are for a sale of the business. This applies both to employees and contractors. And so if you are employed in California and you have a non-compete or non-competition clause in your agreement, you can just strike that. It's not enforceable. There was a proposed ban, and that is on a state by state basis. So there are some states that will enforce non-competes. California is not one of them. We're a very employee friendly state, but there are some states that will enforce non-competes across the spectrum. So I would say, there are some states like Massachusetts that have always enforced non-competes. Other states like, I think, Texas and Washington, they will enforce non-competes, but they have to be more narrowly tailored. So, for example, in those states where non-competes maybe are for 10 years after an employee leaves an employer, and it's, it covers a broad geography, those tend not to be enforced even in states that recognize non-competes. So the non-competes should be fairly narrowly tailored. There was a proposed ban on non-competes at the federal level last year, but that ban is on hold. So what does a ban mean? I mean, basically it was at the federal level, the Federal Trade Commission was telling employers that regardless of where their employees were located, non-competes were not enforceable. But for the time being, individual states can still enforce non-competes if they choose to. So that's something that, I think with the new administration, we'll have to see how that plays out. There's a lot of things that, are kind of, we're kind of holding our breath to see what will happen with the new administration. This is one of them. Non-solicitations. So those are no longer enforceable in California. Again, except in the sale of business. And what I mean by a non-solicit is where there's a restriction on hiring like a former colleague. So, Nikki leaves UC Davis, and he goes to, Stanford University of all places. She might have signed an agreement that contained a non-solicitation clause, and so that non-solicitation clause might preclude Nikki from hiring another colleague from UC Davis to join her at Stanford. But the situation where those are enforceable here in California is it's tied to the protection of trade secrets. So if Nikki had trade secret information about how, you know, how these programs are structured or organized. Um, and that's the reason for the non-solicit. Then maybe the non-solicit could be enforceable, but it needs to be drafted, in a fairly nuanced way. To make sure that it doesn't fall into that kind of unenforceable, kind of bucket. And then, we talked about the PIAs. A founder has ongoing obligations under its PIAs with its former employers, even though it's no longer employed, right? Employed by them. So once you leave a company, that doesn't mean that all of a sudden you're free to disclose all of the company's trade secret information, right? So those obligations that you signed up to under your agreement when you first started working for a company, they remain in place even after you depart your employment. And regardless of the reason why you left that company, right? You leave on your own, you got fired, you got laid off, those obligations in the PIA are ongoing. I also mentioned university policies here. The university policy, why is that important? So, Davis, like many universities, they have intellectual property policy. They govern who owns developments made by professors and graduate students. Because universities are amongst some of the most active, I guess, innovators in the world, right? So, if I look at the companies that get started here in the Bay Area, around the Sacramento area, companies get started oftentimes around universities because their professors or students are coming up with ideas while they're in school. And so the universities have gotten smart and they've developed these policies around who owns the intellectual property that might be developed by the professors and the graduate student. And so if you're a professor, if you're a graduate student working on something, and you want to take that invention or take that idea and build a company around it, my recommendation to you is to make sure that you have reviewed the policies, the IP policies, the IP, from the Office of Technology Transfer, to make sure that you understand what your obligations are to the university. And in some cases, you've obtained the necessary consents, approvals, or waivers. True story here. Probably about 8 years ago, I worked on a merger where our client was being acquired by a very large technology company here in the Valley. The company that we were representing, the client, was started out of Georgia Tech, out of the Georgia Tech research consortium. So they had professors sitting on their advisory board, and they had a professor as a founder. At the time, Georgia Tech had a pretty aggressive IP policy that required its professors to get a waiver from the university if they were going to be involved in any outside kind of consulting or starting a company, using any of the kind of developments that they came up with at the university. So by the time we started working with this client, the company had been around for like 5 or 8 years. And they had not obtained the necessary waiver from the university. And when the large global tech company that was looking to acquire them did their due diligence, started looking at this issue, they realized that the waiver had not been obtained. And as a result, there was a risk as remote as it might be, because now it's like 5 or 8 years later. The tech company, the acquiring tech company, identified this risk that Georgia Tech could come back and claim ownership over some of this core IP that the company was built around. So what was the outcome of that issue that was identified? The purchase price was cut by about 30%, and the amount of money that the shareholders in this company were going to receive was held back for a period of 2 years, I think. So, and the reason why the tech company, the acquiring tech company did that was they wanted to reduce some of their risk if in case Georgia Tech was going to come back and claim ownership over this intellectual property. And so that's why I say you don't want these issues to pop up at inconvenient times. Because that's when you can be held hostage by an employee or a consultant or a contractor that now realizes they need you, you need them to sign a piece of paper in order to get money from investors or in order to move forward with an acquisition. Or you face the risk that the $800 million acquisition price that you were counting on gets reduced by a significant amount to reduce some of the risk of the acquiring company. So that's a long way of kind of explaining why doing some homework and doing some legwork up front when you're starting off your company is super important. So what do you need to make sure of when you're looking at IP ownership and protection for a startup?
And we've got another question, Vicky.
Yep. So if a company reverse engineers the trade secrets of your company, is it possible to sue them? So the answer is it depends, because reverse engineering is actually permitted by trade secret law. You can reverse engineer something to figure out how it works. If the company reverse engineering the trade secrets of another company, had an agreement in place, and that agreement had a provision in the contract that restricted reverse engineering, then you can sue them for breaching that no reverse engineering provision. So I spend my days negotiating, drafting all types of technology and agreements and IP license agreements. They often include this no reverse engineering clause. And the reason we include that is for exactly this reason, is because trade secret law allows reverse engineering, but it doesn't mean that we can't include a contractual restriction on reverse engineering. Okay. So what does a company need to make sure it does when it's starting off? You need to make sure that you own the intellectual property. So how do you do that? You get the written assignment, right? Written assignments from the consultants and the contractors. You get them from the employees. And then you enter into appropriate development and license agreement. So, just like the question on reverse engineering, you make sure that you have an agreement in place that contains clauses that make it clear you own the IP, you are granting only the license rights that you need to grant to another party. It includes appropriate, restrictions on the use of that license, like a no reverse engineering clause. You make sure that what you're licensing or what you're providing is only the object code of a piece of software, as opposed to the source code. So there's all kinds of things that need to go into these agreements to protect the company and make sure that you own the IP. Remember, we talked about, and again, depending on what we're talking about, these agreements need to be tailored. So if you're talking about a drug, or a formula, or, a chip, that's going to be different from, say, a software company. And so that's where, engaging with a lawyer that understands the nuances of intellectual property protection, given different types of technology, different types of intellectual property, different business models is super important. So remember we talked about, just taking software as an example, we talked about the rights granted to copyright owners. So if you're licensing a piece of software, you are granting the right to use, the right to reproduce, but do you really want to grant the right to create derivative works or create modification? Maybe not, because if you're granting the right to create derivative works, you may also need to grant a right to the source code, right? Because if you only have for those of you who are familiar with coding, if you only have object code, it's very difficult to actually make changes without the source code. And so you really need to tie the license grant language in an agreement to match up with what you're actually providing. And so that's why I say, the development and license agreements, especially now with artificial intelligence, like I joke that because I've been practicing for 30 plus years, and with artificial intelligence now, maybe like retirement is going to come sooner than I think, because there's a lot of agreements that you can find online, or you have ChatGPT create an agreement for you. We've played with that on our own, but the agreements honestly don't take into account all the nuances that we need to be taken into account from 30 plus years of doing this type of work. And so I guess that's a cautionary tale about how you might take a template that you find online, or how you might take something that you find using, or that you create using ChatGPT, right? There's nothing that I think can replace the judgment that comes with working with experienced lawyers in drafting some of these agreements. What else do you need to do? You need to exercise a duty of reasonable care. Remember, we talked about trade secret protection. If you want to have trade secret protection, you need to make sure that you're taking steps to protect the information that's trade secret. So don't publicly disclose information, which also includes, as an example, don't put trade secret information into prompts that are going to be fed into an AI engine. Make sure you have confidentiality agreements signed with all your employees and consultants as part of the onboarding process. Make sure you have appropriate firewalls and email security in place. Don't post your source code on GitHub unless you are prepared to make it open source. So, if you're having in-person meetings and you have a whiteboard, make sure that people know they gotta erase everything on the whiteboard after they leave the conference room. And then, making sure you understand which IP protection applies. Patents versus trade secrets, those are mutually exclusive. You can't have both. The reason why you can't have both is because once a patent application is filed, generally about within 18 months, the application is published. The reason for that is we want to encourage innovation, right? And so, and if once the application is published and everyone knows how the invention is working, remember on the prior slide, we talked about no public disclosure for trade secrets, if you want to maintain trade secret protection. So that's why those two types of IP protection are mutually exclusive. You can have, for a piece of software, you can have both copyright protection as well as trade secret protection. And you can have software that, has a logo or a trademark attached to it. So you really need to understand the different types of IP protection and then how it might serve to protect the intellectual property of your given company. Making a decision about patent protection versus trade secret protection is often a key question for companies. And particularly given that some software patents are subject to challenge, that's where, making a decision about maybe protecting the software with trade secret might be, a better strategy for certain types of software. There are different types of patent applications. So there's a provisional patent application, which you can think of as kind of like a temporary patent application. It's really easy, relatively easy to complete a provisional patent application, but it basically puts a stake in the ground and gives you time to think through how you're going to write the claims with the help of your patent attorney to develop the more fulsome utility patent application. And patent applications can be expensive. A single patent application here in the US can cost anywhere from $12,000 to $15,000. And if you're a startup company, that can be a significant investment. And if you're thinking about filing in multiple countries, that's where, thinking through the IP strategy with the business strategy is super important. You don't need to file a patent application in a country where you're not planning on generating any revenue, or you're not planning on selling a product, or you're not planning on manufacturing a product. So that's a good example of why thinking about aligning your business strategy with the IP protection strategy is really important. We talked about, whether or not it makes sense to register the copyright. We talked about whether or not it makes sense to register the trademark or not. And then where to obtain IP protection. That again is, very much about thinking through where the company is going to generate its revenue, where its priority markets are, and then making sure that the IP protection is synced up with those that business strategy. Nikki, how are we doing on time?
We're about 10 past the hour and we have until 1:30.
Okay. So what do you do if you're introducing your company? You want to I often get asked this question, like if I'm talking to a prospective investor, how do I get them interested in wanting to invest in my company? The founders or the companies often tell me, well, I need to tell them about my invention. So how do I keep it, how do I get them interested without disclosing the crown jewels or the trade secret information of the company? Because oftentimes you might talk to an investor and they might be talking to one of your competitors. So you don't want to disclose information to the investor. Have them decide not to invest in you, but then decide to take that information and invest in a competitor of your company. So my advice is always to talk about the what as opposed to the how. So you talk about what the company does, what the company is doing to differentiate itself in the marketplace, but you don't talk about the how in terms of the invention. You don't talk about how you come up with this new chip that might, reinvent how, AI is being handled, right? But you talk about the what, what is it that you come up with? What's the invention? What's the market that you want to tackle? So you come up with a non-confidential description of the company, of the products, and you can maybe provide some very brief technical details, again, just to kind of whet their appetite and get them interested. And then you talk about kind of the competitive advantage that you think that you can provide and the business advantages. And then you can talk about maybe some of the strategy around IP protection, but you don't give them the details about the claims, right? So that's how you how you introduce the company. If you're talking to sophisticated investors, they will very rarely execute a non-disclosure agreement. So like if you think about the venture capitalists on Sand Hill Road, don't even ask them to sign an NDA, they won't do it. They see too many companies and they're not going to risk being the target of a lawsuit or breach from non-disclosure agreement. And the reality is, enforcing non-disclosure agreements is super difficult to do, especially when you're just getting started as a startup. You know, lawyers are expensive, and I'll admit that, and the cost of suing, you know, a sophisticated investor like a venture capitalist on the basis of a non-disclosure agreement usually is not very cost-effective strategy. And then we talked about this already. You'll treat everything as confidential. You safely guard your business and technical information, marketing plans, you know, maybe priority markets that you want to target, and then you use confidential disclosure agreement. You want to make sure that everyone in the company understands that IP is important. You know, going back to the very first slide around the relative value of intangible assets to tangible assets. If you're a company where IP is going to be a core asset, and my guess is that, you know, most companies are those types of companies these days, you want to establish a very IP savvy culture. You want to make sure that everyone understands the importance of IP. Everyone understands what the company's IP strategy is, and that the companies, the employees understand, and employees, consultants, contractors, whoever's working on behalf of the company understands that following that IP strategy, abiding by the company's IP and security policy are critical to the company's success. Again, all good facts. If you're ever faced with a trade secret claim, so that you can show that you've taken active, affirmative steps to protect your intellectual property, especially the trade secret information, as valuable, as a valuable asset. Okay. Strategic IP planning. We talked a little bit about this already. You know, aligning the business strategy with the IP strategy. You need to make sure you're executing the business strategy in a manner consistent with preserving the IP rights and IP protection. And you know, thinking about those priority markets, and that's going to change over time. You know, you might have a priority market, say in Canada, for the next 6 to 9 months, and then you do well in Canada, and maybe you're expanding into other countries beyond that. You need to make sure that your IP strategy is evolving with the business strategy as the business expands. We have a series of guides called Guide to Going Global, and it's all about business expansion. So, you know, as you're expanding into new markets, what are the considerations that you need to keep in mind, both from a IP, corporate, tax, employment perspective, and it's all about aligning the business strategy with kind of these key operational considerations, IP being one of them. We talked a little bit about this. You know, there's different types of licenses. You know, and it's difficult in a single slide to cover all the different types of licenses, or technology agreements. But you know, thinking through what type of license a company needs, both in terms of what you're granting to potential partners, business partners, or customers, and both in terms of what a company might need in the way of a license being granted to it by a third party. Some licenses might be exclusive, some might be non-exclusive, there might be geographic limitations, there might be field of use limitations. So thinking through those alternatives are going to be super important to make sure that you have the right agreement in place that's, again, aligned with your business strategy.
We've got another question in the chat. Let's see, do you have tips with how to afford establishing legal documentation for startups looking to patent hardware prior to gaining external funding to protect later potential patents?
Yeah, so that's where the provisional application can be really helpful. The provisional application will at least buy you a year to file a utility patent. So there is what we call a time bar. So from the time that you disclose an invention to the time that from the time once you disclose an invention um in a like a public way, so without a non-disclosure agreement in place, as an example, you have 1 year to file the patent application. That year, you can buy more time if you file the provisional patent application. So the provisional patent application can usually be done for a couple of $1,000s. We have inventors who do that themselves. So that's a good way of saving some money. And then the other way is, again, just making sure that you're thinking about filing patents only in the jurisdictions that that are kind of your near-term priority. Okay. Let me see.
Got about 5 minutes or so, just to
Yeah.
give you.
One other thing to think about is, you might have a situation where someone just wants to try out your technology, right? So in the evaluation agreement, it's usually at no cost. You have fewer rights that are granted, but again, it's, you can think of it as a proof of concept or a trial agreement. So there are different ways to, kind of seed the market, to get people interested in maybe taking a paid license from you. So there's creative ways that you can execute on the business model. And then the last thing is, I mentioned earlier due diligence. So due diligence is the process that investors and acquiring companies go through to make sure that they're investing in a company that's not vaporware. That there's actually something that they're investing in. That if a company is getting acquired by another company, that what the company says it owns, it actually does own. So that's the due diligence process. And so all the agreements that we talked about, all the IP strategy, where you file for patent protection, whether or not you have you've taken steps to protect trade secret information, those are all issues that an investor is going to be looking at and an acquiring company is going to be looking at, because they want to make sure that all this money that they're going to put into this company, either as an investment or as a purchase, is makes sense, right? That they're buying assets that they're actually buying the assets that they're being told are owned by this company. And so that's the process of due diligence. And so everything that we've talked about is to put your company in the right position to be able to respond positively to this due diligence process. Again, so you don't end up in a situation where there's some skeleton in the closet that you didn't know about, and now you have to remediate that in order to get the investment or in order to move forward with an acquisition, right? And so making sure that you keep kind of these housekeeping items in order is super important to lay the right foundation for the future, what we call an exit strategy for the company. So with that, I'm gonna wrap up and Nikki, I will send you an update with the January 2025 data on that one slide, once I figure out why that happened. But any other kind of lingering questions before we sign off here?
I don't see any more in the chat. Does anyone else have a question while we have Vicky here? We just want to say a huge thank you. So let's see. Is there an overall approach to think about protecting IP and NDAs? As a company based that is innovating based on IP, we'll have employees, consultants, partners, sign NDAs with us, but they may need to disclose certain information to other people while working with us. Is there guidance we can give to our partners and employees on what is okay to disclose?
For example, anything, yeah, I mean, if it's publicly available on your website, then yes, we could certainly disclose that. The issue really is, has someone made an assessment that what's publicly available on the website is appropriately disclosed on the website, right? I'll put it in the, let me see if I can put in the chat here. There is a website that we have for founders, that has a whole bunch of little articles, that are written in non-lawyer language, generally pretty easy to follow. And it talks about the different categories of IP and different considerations. So if you haven't seen that yet, I encourage you to take a look at this website. It's a pretty good resource it's geared towards entrepreneurs. But you know, feel free to take a look at that, and I think that should provide some guidance. What are your thoughts about applying for a provisional patent before conducting a proof of concept? And then applying for funding. Do you mean applying like for grant funding to create a proof of concept? Or I'm gonna assume that that's maybe applying for like grant funding. So depending on the grant, you can certainly seek funding to do a proof of concept. But the proof of concept, if you can do a provisional patent application before the proof of concept, that would be ideal. Failing that, make sure that you have an agreement with whoever you're doing a proof of concept with, and that agreement contains a confidentiality clause. Because if you don't have a confidentiality clause in place, then you're at risk for someone saying, well, now the 1-year time bar has started, and you have to file your utility patent application within a year after you entered into the agreement to do the proof of concept.
Fantastic.
Okay.
Gosh, thank you, Vicky, so much. Your depth of knowledge and expertise on this topic is amazing. That you give us your time each year to do this is just wonderful. So thank you so much. Just a couple of announcements before we sign off. Our round 1 of the Big Bang, the registration is due March 3rd. So remember that date. If you're interested in doing the Little Bang before entering the Big Bang, that one's coming up February 6th is the registration date. February 10th is when you need to have your poster submitted, and then the actual event is on February 13th. So all of that is on our website. You can take a look at that. And then finally, our next workshop is on January 22nd, so next week, same time, and it's on the business canvas, so framing your approach with Joe D'Annunzio. Should be a great workshop as well. So thank you all for being here, really appreciate it. Hope you have a great afternoon.
Hey, thanks everybody.